Hello, viewers. I welcome all my audience to this session today of copyright law. Well, if you are a student of MAJMC or PGGMC at IGNOU, this is your Unit 10, which is a part of your Block 3 in your course MJM025, the course on media ethics and laws. You would have probably seen the earlier videos in this series, which we started with the introduction of the course. Then we proceeded with each of the units. Today we have reached Unit 10. We as individuals, particularly if you are in a profession of creating something, and these days everybody has turned a prosumer. Even if you're not an academician, artist or a literary person, you probably would still be creating some content for a social media site or any kind of an intermediary. Now, do you hold a copyright to this? What does copyright mean? We'll discuss these basic things today. Friends, let me tell you about the unit structure, where we begin with the definition of copyright, main features of copyright being the determination of ownership and the rights of the copyright owners, registration and assignment, where the rectification of registration, publication, terms of copyright, assignment of copyright, mode of copyright, licensing, which is licensing by the owners, and also licensing of the works that are withheld from the public. And then we shall wind up with the infringement of copyright, where we'll discuss the guidelines of measuring infringement, acts which do not contribute to infringement, and remedies against copyright infringement. Broadly, we shall discuss all this in this unit. Now, as you would understand, we shall discuss what is copyright first, and then we'll come to the particular law in India, which is the copyright law. Now, friends, to introduce the concept to you, to protect the interests of the creator and advancement of knowledge and learning, copyright legislations have been enacted worldwide. India, being the signatory member of TRIPS and various other international agreements, has comprehensively enacted the Copyright Act of 1957, and several amendments have been done from time to time to meet the changing requirements of the society in this act. So, though it is an Act of 1957, which is more than 50 years old, but various continuous amendments have kept it very topical, comprehensive, and even applicable to the present times. In this unit, we aim to provide you with an overview of various provisions of this Copyright Act in India, indicating registrations, licensing, remedies, infringements, and also discuss what the amendments entail. With this in mind, let us come to defining a copyright. Only when you understand what a copyright is, what do we mean by it, will you be able to appreciate better the law of the country and even certain international amendments, acts, provisions in this context. Copyright is a legal right granted to the creator of an original work. Now, the underlying word here is original. This might include literary, dramatic, musical, artistic works, as well as certain other intellectual properties. This provides the creator exclusive rights to use, distribute, authorize some other people, or to use the work for a specified period or purpose. So, if you have created something, you would know that a lot of effort goes into making it. How do you protect that effort from being copied by certain people in an easy manner? This is where the copyright comes into domain. What are the main features of copyright? The main features, as I said, is originality, which means copyright protection applies only to original works or authorships. Fixation. The work must be fixed in a tangible manner of expression. You just can't say, oh, I was dreaming of this idea and I want to copyright it. It has to be something tangible. Either you put your idea on paper, in a model, in a flowchart, something which is seeable, usable, which is tangible in nature. So it has to be fixed there. That is where the copyright can help you protect your idea. Then there are the concepts of exclusive rights. The copyright owner has exclusive rights to reproduce, distribute, perform, display, and create derivative works from this one original work. There is a chemical formula that you've come up with, but if you can come up with a vaccine or any other drug or medicine from this formula, then also you hold the copyright to these derivative works, be it in science, social science, artistic films, anything, these copyrights are there. Main features of copyright are that it is territorial in nature and it holds a particular duration, which means territoriality means copyright laws vary by country. Protection is generally limited to the territory of the country which is granting it. So that means if you are copyright something in India, not necessarily that in Germany also your copyright would hold. And for this, as we looked at in some of our previous units and videos, some international laws like the Paris Convention, the Berne Convention, the Rome Convention, they do put the intellectual property rights which are there across the territories. But till that, if it is not protected under an IPR, copyright laws usually vary from country to country and they hold validity only in that specific geographical area. The second thing that you must be conscious about is the duration. Copyright protects in a manner which is limited in time. So copyright protection is time limited, lasting for the life of the author plus some additional numbers of years. Now this might vary from country to country and also from content to content. Usually it is for the lifetime of the author or the person holding the copyright and also for certain other preceding years after that. Now determination of ownership is very important in copyright. What does the owner entail? How do you determine? Ownership of copyright is typically vested in the creator of the work, but it can also be assigned to others. Now let us look at the domains of these ownership. First can be authorship. The person who creates the work is the author and generally the copyright owner. Then joint authorship. If a work is created by two or more people, they are joint authors and share the ownership of that particular work. Works for hire. In certain cases, such as employment, the employer is considered the copyright owner. So if you were being paid for creating something, somebody has employed you, deputed you, hired you for creation of that work, then the person who has paid or employed you for that work has the automatic ownership of that kind of product or something that comes out of that. There is the fourth concept to it, which is the reproduction right. The rights to reproduce the work in any form lie either with the author or with the owner of the copyright. Distribution of rights. The rights to distribute copies of the work to the public is also covered under the copyright. Performance rights, that is the right to perform the work publicly, or display rights, which means the rights to display the work publicly, and the derivative work right, the right to create adaptations or derivative works from the original work. All these are covered under the rights of the copyright owner. Now, how does a person register? What are the assignments of the copyright? Assignment. Copyright can be transferred to others through an assignment agreement which must be in writing. You can't say, oh, verbally I told my friend, you can use my work. I have written this play and you can perform it on stage. No, it has to be a written contract or an agreement. Registration. Through copyright protection, though it is automatic, like if I write an academic paper and I publish it in a journal in my own name, then automatically the copyright lies with me as an author. Though copyright protection is automatic in this context, registering the work provides legal evidence and protection. There are certain cases even in films where people say, oh, this film was made but this story was originally mine. So now writers have started registering their stories in the Copyright Act and law so that they are able to claim. Otherwise, if I make a film and you come out later, there were instances where people came to Chetan Bhagat and they said, okay, this book that he's written was originally my idea. Now, unless and until you have a registration, you have a proof in paper, how do you claim that to be your idea? So sometimes people misuse this kind of gray area where they claim, okay, this film is mine, this novel is mine, but they cannot win a case in the court unless they are able to prove it. And sometimes even bigger authors, bigger filmmakers can misuse it. So it is both ways. I mean, just to get popular, some lay people can erroneously, flawly, lying claim that work to be there. And at other times, the powerful, people in the creative industry can actually get hold of works of smaller people and claim this to be theirs. Therefore, this law is very, very important. We'll come on to discuss the law. As of now, we're just discussing generally what is copyright. Now, rectification of registration. Once you've registered your work, can you rectify? Of course, you can. Rectification involves correcting errors or omissions in the copyright register, where you have to put an application. The owner of the copyright or any interested person can apply for rectification. The Copyright Board has the final authority to rectify this registration. If they find it valid, they find it worthwhile, they are the authorized people to allow you for this rectification. Now, publication and terms of copyright. Publication means the distribution of copies of a work to the public without the consent of the author is define the copyright. So, if you have to publish, you have to do it with the consent of the author. The term of the copyright varies depending on the type of work, generally lasting the author's lifetime plus about 60 years. Now, it again varies, as I said earlier, from territory to territory and from the nature of the work, the content, what it is of type. But generally, usually in India, the copyright law says the lifetime of the author or the creator at plus 60 years. Assignment of a copyright. An assignment means the transfer of the ownership of the copyright from the original owner to another party. Now, there has to be a written agreement. The assignment must be in writing and signed by the assigner, and the scope is the assignment can be for the entire copyright or even for specific rights. So the author might say, okay, I give you only the right to make a film on this, or the right only to create a play on this, or you can use my kind of tunes that I've created in a musical composition for a particular song, or I give you the entire right of my book. You can either make a film out of it or design a play out of it, do critical analysis, anything you can use it for. So this depends on the author, where do they want to give the copyright, either for specific areas or for the entire work. Mode of assignment is therefore either it can be specifics, the assignment must clearly specify the right being transferred, the duration and even the territorial extent. And then the considerations are the agreement should include the consideration that is payment. So there has to be a payment which is involved, and you have to write that in the agreement very, very clearly. So whatever the consideration for transferring either the rights of a particular portion or the entire document or an entire work, there specifically has to be written, transferred, duration, territory, and the considerations. That means the monetary transactions involved have to be clearly told in that. Licensing of copyright. Licensing allows the copyright owner to grant permissions to others to use their work under certain conditions. Whatever licensing you've given in a particular territory for a particular domain of a particular part has to be clearly specified here. So licensing can be of certain types. It can be either an exclusive license, exclusive rights to use the work excluding even the copyright owner, where if I grant you an exclusive license, you will be the sole owner of my work and I would also lose the rights to it even being an author or owner. And then there can be non-exclusive right, which allows multiple parties to use the work including even the copyright owner. So somebody can write a book on my work, on my idea, somebody can make a film on it, somebody can make a musical out of it. This is about the artistic works I'm talking. And if you have a literary work or an artistic work, this is this. However, if you have a scientific work, you've come up with a model or a certain invention or a discovery, and you give it to people, somebody can make some medicines out of it, some people can put it in the books for other people to learn from it. So there can be licenses given to multiple parties also, where the owner also is a party and there are multiple other people who can own this. Licensing has different categories. We spoke about exclusive, non-exclusive, and now there can be voluntary license. That means the copyright owner can voluntarily license their work to others, and there are compulsory licensing, which means in certain cases, the law permits others to use the work without the owner's consent, usually under specific conditions. If the law feels this is a work for a national development, national security, or in the public interest, they might not wait for the consent or the voluntarism offered by the author, and the law can just tell people, okay, you're free to use this work for this specific area. Now, this is a very special circumstance, and it's not usually the case. But you should just be aware, even if it's a special circumstance. Now, there is another category of licensing, which is in the works which are withheld from the public. If I've made something and I do not want to make it public, I withhold the work from the public. In such situations where the copyright owner withholds a work from the public, the government may issue a license to others to publish or use the work in public interest. So time and again, friends, when we're looking at this whole course of media ethics and laws, something public interest. Now these two words come in again and again. That means you can also be excused from an act which is unlawful if it was proven to be in public interest. If there is a copyright and the owner wants to withhold it from the public, but if it is in public interest, the government or the state or the law would permit the people to use it. Now, this remains the underlying motive in any of the laws in our country. Infringement of copyright is what we come to next. Copyright infringement occurs when someone uses a copyrighted work without the permission, violating the exclusive rights of the copyright owner. There can be different types of infringements which can be direct, contributory, or even vicarious infringements. Examples can be copying, distributing, performing a work without the authorization or permission of that particular creator. Now, if there are infringements, there would also be guidelines to measure these infringements. Now, there are specific guidelines where what can be taken as infringement. If you told me a story and I used a certain example from your story in my class, can I be held lawfully responsible for infringing upon your copyright, or is it permissible? Let's look at it. Guidelines for measuring infringement include substantial similarity. You have to assess whether the alleged infringing work is substantially similar to the copyrighted work. Access, you have to determine if the alleged infringer had access to the copyrighted work. Now, this is of importance. As I said, one of the authors came up and said, okay, Chetan Bhagat has taken my story. Now, if Chetan Bhagat has never met that person, had no access to that story, can he be liable for stealing that story? Now, this is very, very important. You have a certain idea. I have a certain idea. How can you say that I've stolen your idea if I've never had access to your idea? So, substantial similarity, access, and copying, which means evidence of copying either directly or indirectly can support a claim of infringement or even can help defy the claim for infringement. Now, acts which do not contribute to infringement are fair use of copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research are thought to be of fair use intentions. We have dealt with this in another unit where we spoke of IPR and concept of fair use. And the minimis, which means incidental or trivial use that is not substantial enough to constitute infringement, is excusable. Parody, use of copyrighted work to create a comedic or satirical imitation, is protected under fair use. So fair use, minimal use, parody or satires, educational use, unintentional use, not having access to the material, all this is not considered as infringement to the copyright. But if an infringement is proven, then what are the remedies against copyright infringement? These are injunction, where the court orders preventing further infringement. There are damages, which are monetary compensation for losses suffered by the copyright owner are given to the person. There can be statutory damages, which is predetermined damages awarded when actual damages are difficult to quantify, or criminal penalties. In serious cases, infringement can lead to criminal charges, fines, or even imprisonment. So the excess of copyright is determined, and then any of these remedies can be implemented as thought right by the law. Now, let me take you back to the law, because now I'll be discussing some of the cases pertaining to this law. So I introduced this concept and started today's discussion with the definition of the law. Let me repeat it here. Copyright law in India is governed primarily by the Copyright Act of 1957 and the subsequent amendments that have been made to it. This legislation provides the legal framework for the protection of literary, dramatic, musical, artistic, cinematographical, films, or sound recording works. Now, what are the main features of this copyright law in India? Friends, copyright protection is automatic in India. It arises as soon as a work is created and does not require registration, although registration serves as prima facie evidence in a court of law. Of course, as I said, as soon as I publish my work, I am deemed to be holding a copyright for it. But it is good to register your work so that in future you may want to protect the infringements, and this acts as a proof. Duration. Duration of copyright varies based on the type of work. Generally, for literary, dramatic, musical, artistic works, copyright lasts for the lifetime of the author plus 60 years after his or her death. Rights to copyright owners, these include the rights to reproduce, distribute, perform, display, or license the work and create derivative works out of it. Now, this law stems from the basic tenets of copyright. Remedies for copyright infringement in India: there are civil, criminal, and administrative remedies that are offered to the people who are actually being wronged. Civil remedies include injunctions to stop the infringing activity, damages, and accounts of profit. Criminal remedies include infringement of copyright can also lead to criminal prosecution, which may result in imprisonment and fines. Administrative remedies: the Copyright Board can resolve disputes regarding assignments, licensing, and rectification of the register of copyrights administratively. So these three kinds of remedies are offered by our copyright law. Now, there have been many amendments in this law, important one being the Copyright Amendment Act of 2012. This amendment brought significant changes, including provisions for protecting the rights of authors in the digital age, fair use for educational purposes, and the rights of the performers. So, as the society is progressing, the amendments were made to the Act to accommodate the new and upcoming requirements of your social milieu. This also gave us the digital copyright concept. This amendment came up with this. With the rise of digital content, the law also covers infringement related to online works, including streaming, downloading, and sharing of copyright content without the permission. If this is done, it is considered to be unlawful. There are certain international treaties which we have discussed in detail earlier in our unit of IPR. Now, India being a signatory to several international conventions on copyright, including the Berne Convention, Paris Convention, Rome Convention, the Universal Copyright Convention, the Agreement on Trade-Related Aspects of Intellectual Property Right, which is TRPS, has to comply to all of these as well. Let me bring you to certain cases. Here are some landmark cases related to the copyright law in India. These cases have played a significant role in shaping the contours of copyright in India and are often referred to in legal discussions and judgments. To you, they will give you a better idea of what you've just studied. I encourage you to actually go out there, research, find out and read more about these cases to have a better understanding. There is R.G. Anand versus Deluxe Films case, which was of 1978. This case is a foundational one in Indian copyright law. R.G. Anand, a playwright, accused Deluxe Films of copying his play Hum Hindustani to make the movie New Delhi. Now, the Supreme Court held that if the viewer, after seeing the work, gets an unmistakable impression that the subsequent work is a copy, only then and only then can it be considered an infringement. It was ruled that although the basic idea might have been similar, the expression was different and hence there was no infringement. Now, friends, the significance of this case lies that this case established mere similarity in ideas does not constitute copyright infringement. The focus should be on the expression of those ideas. Another important case is the Eastern Book Company versus D.B. Modak, the case of 2008. The dispute involved the copyright of judgments that was published by the Eastern Company. The issue was whether the publisher could actually hold and claim copyright over the judgments which are in public documents. The Supreme Court held that while the judgments themselves are not subject to copyright, the manner in which they are compiled, edited, and presented could be copyrighted. This case clarified the extent to which public documents could be copyrighted, emphasizing the importance of originality in expression of these documents. So these two cases tell you that expression is also important. Merely possessing the information will not give you the copyrights. Another very important case, especially for the media students, is the Super Cassettes Industries Limited versus MySpace Inc. case of 2011. Now, Super Cassettes, a leading music company, sued MySpace for hosting copyrighted content uploaded by the users without authorization. The Delhi High Court held that intermediaries like MySpace could be held liable if they do not act expeditiously to remove infringing content upon receiving notice from the copyright holder. You might say, I did not know this happened. But when the owner is approaching you, then you have to act actively to remove something which is a copyrighted material. The significance of this case highlighted the responsibilities of online intermediaries in managing copyrighted protected content and shaped the understanding of safe harbor provisions under the Indian laws. So harboring your material also has to be safe. We come to the next important case, which is the Civic Chandaran versus Emini Amma case of 1996. Civic Chandaran was accused of copying significant portions of a drama, which is Niglene Communistica, in his play Nigel Arene Communistiki. Now, this case was taken to the Kerala High Court. Kerala High Court ruled that in cases of parody or satire, some level of copying is permissible as long as the copied portion is used for commentary or criticism and does not amount to wholesale reproduction. If there is not a wholesome reproduction of the work, certain portions for criticism, parody, satire were permitted by the Kerala Court. This case is very important as it set a precedent for the fair use doctrine in India, especially considering parody and satire. The Chancellor, Masters and Scholars of University of Oxford and ORS versus Rameshwari Photocopy Services. A very important case for us as students of 2016 case. Now we all as students have relied on photocopied portions of certain books. This case provides inputs into this. Now, Rameshwari Photocopy Services, which provided course packs containing photocopies of chapters from textbooks. The Delhi High Court ruled in favor of the photocopy shop, stating that making course packs for educational purposes fell well within the ambit of fair dealing under Section 52(1)(1) of the Copyright Act. Friends, this case was crucial in interpreting the fair use doctrine in the context of education and reaffirmed that photocopying for educational purposes could be permitted. Now friends, with the knowledge of the copyright law and certain cases at hand, you have a fair amount of understanding how to protect yourself or how not to infringe upon others' copyright. But this merely is not enough. It is a very challenging situation as there are challenges and emerging issues. As the society is progressing, new challenges keep on emerging. Therefore, we have the need of coming up with new conventions, new acts, new laws and even amendments. Digital piracy is an emerging challenge. As digital content consumption grows, privacy remains a significant challenge. Copyright in the AI-generated works. Now, with the advent of AI, questions arise about who holds the copyright for works that are generated by machines or machine learning softwares. There are global enforcements. The internet's borderless nature poses challenges for enforcing copyright law globally. All this is challenging. Now, certain new cases, for example, there's an impinging case in the High Court which is challenging Google, Twitter, Instagram, that how much of information can actually be archived. If there are criminal laws about a person, if there are criminal records about a person who has now served his or her punishment and trying to lead a good life, a law-abiding life, the previous records, the footprints which still remain in the internet pose an issue. Now, people are putting up these cases to the courts to give judgments in these regards. I hope all this knowledge would help you have a wonderful understanding of copyright. To sum up today's content, we discussed copyright as a concept, then we went on to look at the copyright from a legal perspective in India with certain examples and cases. India's copyright law seeks to balance the interests of the creator and the public, ensuring that creators can benefit from their work while allowing for fair use in certain contexts and contents. With this, we wind up this basic unit, which was your Unit 10 of Copyright and Copyright Laws. Wishing you a very happy learning experience. All the best.